Hi everyone, this is Gideon V. Wainwright, 1963. So for some background, Clarence Earl Gideon only had up to an 8th grade education, so he was a middle school dropout, which is kind of crazy. He had run away from home at a young age, and as he grew into his adulthood, he became this sort of drifter who went in and out of prison for nonviolent crimes. On June 3rd, 1961, Gideon broke into a pool hall in Florida. He wrecked a cigarette machine in order to remove coins from it, and he stole some cash from inside a register. He was arrested shortly after and got sent to trial, but this wasn't new to him. He had gone on trial on several occasions in different states, and because he was poor, the courts appointed him a lawyer to represent him at no charge. However, the law in Florida stated that the state will only appoint a lawyer to a defendant in a capital case, which is a case where the defendant could face death penalty. So because of this, Gideon was not entitled to representation by the state. He started to act like his own lawyer, but that backfired when he was convicted and got sent to prison for 5 years. He did go on to appeal his case, and it was brought before the Florida Supreme Court.
What crime did Gideon commit for this specific case? A. Theft. B. Murder. C. Breaking and entering. D. Aggravated assault. So the petitioner's argument, aka Gideon's, was that this case was based on the Sixth Amendment, which says in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. But the Sixth Amendment, as written, only applies to the federal government, and the state government was denying Gideon a lawyer to represent. This loophole, the Sixth Amendment, was technically not being violated because Gideon was not standing trial in a federal court. However, now the 14th Amendment Equal Protection Clause applies the liberties contained in the Bill of Rights to the states.
What amendments were used in his argument? A. 6th and 7th, B. 4th and 1st, C. 9th and 13th, or D. 6th and 14th.
The defendant's argument, also known as the respondent, was Louis L. Wainwright, who was Florida Secretary of Corrections during this case. The main claim was that the Constitution does not require states to provide free lawyers to defendants in non-capital cases. It was also under the earlier case of Betts v. Brady in 1942 that the Supreme Court for that trial ruled that states had to appoint counsel in special circumstances, for example, illiteracy. It was said that each state should decide for itself whether or not and when they should provide counsel for nonviolent cases, because if they had to appoint counsels for all felony cases, it could potentially burden the states and their public resources. What principle did Florida rely on in order to deny counsel to Gideon? A. The Sixth Amendment automatically binds state courts. B. The special circumstances rule from Betts v. Brady. C. Equal protection requires counsel in all trials. Or D. Federal courts control all state procedures.
So the Supreme Court, led by Chief Justice Earl Warren, had the decision of ruling unanimously in Gideon's favor with a 9-0 vote. They agreed the Sixth Amendment statement of providing a lawyer does indeed apply to states via the 14th Amendment's Equal Protection Clause. The unanimous majority opinion, which was written by Hugo Black, said that the right to counsel is a fundamental and essential part of a fair trial. He went on to explain that a defendant facing criminal charges cannot adequately defend themselves without a lawyer, especially if they are poor or uneducated. He also criticized the decision made during Betts v. Brady, saying the special circumstance rule was inadequate for ensuring justice. He said that lawyers in criminal courts are necessities, not luxuries. Who wrote the majority opinion? A. Earl Warren, B. John Wick, C. Hugo Black, or D. Clarence Gideon.
The reason this case matters is because it truly does incorporate the Sixth Amendment into the states. Because of this, states were required to fund and train thousands of public defense lawyers who could be called any time to defend clients who are not able to afford their own lawyer.
The AP curriculum chooses to study this because it's a great example of selective incorporation. It helps reinforce the Equal Protection Clause of the 14th Amendment, and it emphasizes that justice must be the same for both rich and poor. The impact this case had was long-lasting, both for the legal system and for many individuals' rights in the United States. It expanded the interpretation of the Sixth Amendment and strengthened the idea that the right to a fair trial applies equally to everyone.
Hey guys, welcome back to day 3 of Gideon's vlog. Today we're doing another breaking and entering to someone's house. Let's do it for a 3rd time.
What's that sound?
Oh guys, look at this guy.
Police?
That's the sound of the police!
Get in there, you punk. What the heck, baby?
Yo, can we stop at McDonald's?
Sure. No!
Ba-da-ba-ba-ba. You
are about to enter the courtroom of Judge Judith Scheindlin.
Order in the court! Wait, where's my lawyer?
This case isn't capital. You don't get a lawyer.
Huh?
Crime, Florida, not capital, no lawyer.
Prosecutor, what's your argument?
He was breaking and entering. I have a witness.
You broke into my house and stalked me.
Defendant, what's your case?
I didn't do it.
I've heard enough. This man's illiterate. 5 years in prison.
Ho, ho, ho!
I don't get paid enough for this. Let's begin. Defense, why are you back?
I read up on my books. I learned that the Sixth Amendment should apply here. I should have a lawyer, no matter what. It applies to the states.
Prosecutor, do you have a rebuttal?
Your case was being trialed under state law, not federal law.
Well, the 14th is the Equal Protection Clause, which allows it to apply to the states.
He has a point. Court, it's time to vote. Who's in favor of Gideon? I count 9-0 in favor of Gideon.
This is CNN Breaking News.
State your name and what are your thoughts on how the Gideon V. Wainwright case ended?
I am Hugo Black, and I do side with Gideon because I believe that lawyers are necessities, not luxuries.